Good afternoon, viewers, and thank you for joining us today here on XPAN. We are excited to present today a live hearing in the Senate on a recently proposed bill. S1199 seeks to increase consumer protection and allow for recourse in instances of data breaches by companies. We now take you live to the floor of the Senate, where Chairwoman Mull is kicking off the hearing with an opening description of the bill and its contents.
Americans are more connected today than we've ever been. Connected to Facebook, Instagram, WeChat, Snapchat, Google, Yahoo, and a plethora of other internet fixtures. The amount of personally identifiable information shared with strangers from the comforts of our own homes is growing at an astronomical rate. And the rate that information is passed from one entity to another is growing even faster and putting us all at risk. While we enjoy many privileges, shopping online, staying in touch with family and friends and loved ones at the tap of a button, our personal information is being exploited by companies looking to make a profit. Today, we invite you to listen to our speakers as we go through HR 911, which states that any consumer whose non-encrypted or non-redacted personal information is subject to unauthorized access and exfiltration, theft, or disclosures as a result of the business's violation of the duty to implement and maintain reasonable security procedures and practices appropriate to the nature of the information. To protect the personal information, they may institute a civil action for any of the following. To recover damages in the amount no less than $100 or $750 per incident or actual damages, injunctive or declaratory relief, any other relief that the court deems proper. This bill goes on to talk about the accessing the statutory damages and how the court may proceed if such damages are necessary. So we'd like to hear from the speakers. Could I have the first speaker please come up?
Good afternoon, Senators and Chairwoman Mull. My name is Alex Nauman, and I'm here speaking against Senate Bill 1199 on behalf of a number of companies. The companies I represent want to first express their underlying commitment to doing right by customers, and this includes being good stewards of information and data. We don't disagree that the assertion that companies should be good citizens in their communities, states, or this nation. Each and every business owner, myself included, are also customers of many other businesses, so we know both sides of the coin well. I'm here today not to tell you that consumer data privacy doesn't matter, but rather to share with you the concerns and ramifications of the way this specific bill is written. The language of the bill is repulsive for business people like me because of the undue pressure it imparts on owners and executives.
Good afternoon, esteemed Senators and Chairwoman Mull. Thank you for hearing me. My name is Jaron Blessing. I'm a plaintiff's attorney specializing in cybersecurity, and I'm here on a representative capacity. My client, Devin Droneflyer, suffered a grave injustice at the hands of bad actors, resulting in his financial ruin and great hardship being placed on his life. I'm going to take a minute now to tell you about Mr. Droneflyer. Mr. Droneflyer is a paragon of the American dream. His love of drone flying has allowed him to take his particular passion and build it into a business that is not only profitable for him, but allows him to provide jobs for other Americans. In the course of the pursuit of his hobby, Mr. Droneflyer used the services of SOB Inc. SOB Inc. stored his data insecurely, including his social security number. They then exposed themselves to a serious data breach, exposing the intimate and personal data of countless consumers. My client's identity was then stolen, by what we can only imagine to be extremely sophisticated identity theft mechanisms. As a result of this identity theft, my client lost his business. His financial accounts were cleared out. His business accounts were cleared out. He defaulted on all of his business loans, putting all of his employees out of work. His life was ruined and needs to have a means to seek for recourse.
Businesses exist to serve the needs of their customers and sometimes society in general. Without direct or indirect users of their products and or services, these businesses would cease to exist. Businesses strive to do right by all stakeholders, including customers, employees, owners, and investors. And sometimes this leads to conflicting positions. One of the hallmarks of being an effective business leader is having the courage and wherewithal to objectively analyze the state of the company and make challenging decisions when necessary. A company must be able to effectively make money through their services and or products. Otherwise, it would be a charity with access to alternate means of funding and additional financial benefits, such as modified tax requirements. Any regulation or law that applies to companies operating in the for-profit space requires resources and time to comply with. This added cost must be estimated and covered by the company out of their operating income, effectively lowering net income and subsequently shareholder value if the company is public. More concerning yet is excessively restrictive legislation that would be nearly or completely impossible to effectively comply with. The organizations I represent here today are all strongly of the perspective that this legislation, especially in the way it's been written, imparts a ridiculously large burden on companies, many of which have nothing to do with the telecommunications or cyber industries. This lack of experience in such fields puts non-technological businesses at a severe disadvantage to comply with regulation such as the bill before us today. Most consumer-facing businesses would struggle greatly to be able to generate the information required in this proposal. This is partly due to the fact that many businesses across industries, size, and geographies rely on third-party services. These third parties are used for payment processing, communications, and customer management. Businesses employ these vendors to provide solutions that allow a company to better serve its customers and other stakeholders by meeting foundational needs, simplifying the transaction process, and creating a more customer-focused experience. On the whole, customers appreciate this effort. More than appreciate, they expect this effort because it's demonstrated through higher customer retention, loyalty, and sales. The overall customer experience is made possible through partnerships with third parties. And in order to effectively leverage the capabilities offered through these services, consumer-facing businesses must share relevant and applicable data with those vendors to facilitate the end goal of meeting or exceeding customers' needs and expectations. Businesses are already held to quite high standards regarding the type of information they are allowed to collect and use in certain cases. And while some of these measures are unduly restrictive as well, these standards mean that by definition, businesses such as those that I'm representing today already collect and use data in a regulated and monitored fashion. Adding additional burdensome requirements on top of that only complicates the issue further and makes it that much harder for companies to run their business, which is at the core of who they are and what they do. Take, for example, a gardening service. Such a company tracks jobs by customer name, address, and phone number, and collects payment through online payment technology. They are clearly collecting and using those pieces of information for completely legitimate and business necessary needs. While this is a simple example, I share it with you to illustrate the point that most companies, especially the ones I represent, are not in the business of collecting and using customer data for malicious intent or in a way motivated by profit potential. They need this information to be able to serve their customers, and they shouldn't be unduly punished for issues resulting beyond standard protection of such information. If anything, this burden should be on the government to protect its people both consumers and business owners.
Senators, I'm going to tell you why you need to pass Bill S. 1199. In the wake of the Spokio case, which has resulted in a circuit split regarding the issue of standing, consumers who have had their data breached are finding themselves in an extremely helpless position. I'm going to take a little bit of time to explain the circumstances surrounding what happened to my client. While it may be an extreme case, it is emblematic of the risks that so many other consumers are subject to all across the country, and should serve as a cautionary tale to this esteemed Congress as to why legislation on the subject is crucial. As I mentioned in my opening statement, Mr. Dronefire's life was essentially ruined as a result of this cyber attack. His only means of recourse was to go to the courts to hold businesses who lost his data responsible for the damage he suffered, including the loss of his business. The courts ruled, like in so many other cases we have seen recently, that there could be no recourse from Mr. Droneflyer, as he could not meet the draconian standing requirement to even have his case heard. The issue of cybercrime is rampant and affects both consumers and businesses alike. Businesses, however, are the only logical place this issue can be curbed. If you do not allow for liability to be imputed to businesses who allow their consumers' information to be breached, customers will be completely left at the mercy of bad actors like the one who stole Mr. Droneflyer's identity. In an ideal world, we would hold the perpetrator, the individual or group responsible for this attack, liable for the damages caused. But we need to account for the reality that the identities of most bad actors will never come to light in these circumstances. Even where attacks are traceable, there is a high probability that the actors is beyond the reach of the U.S. jurisdiction. Creation of a statute that would give injured customers better access to the courts is an important step forward in the fight against cybercrime. Currently, businesses have little incentive to stay up to date on their cybersecurity. Holding companies like SOB Inc. accountable would let businesses everywhere know they need to focus on security and not just efficiency. My client, who is representative of so many thousands more consumers, suffered a grave abuse and was unable to seek redress in the court system. For this reason, this Honorable Senate needs to step forward and produce legislation that can bring together both sides on this matter to find a solution that protects everyone, not just corporate interests. In Droneflyer v. SOB Inc., my client's case was dismissed due to a standing requirement that places a heavy burden on the consumer side, allowing businesses to escape the responsibility of their lack of cybersecurity. In Spokio, the court took a narrow view of standing that does not take into account the reality and nature of data breaches. There are 3 requirements that a plaintiff must meet before the merits of a case can be heard before a federal court. Those requirements are 1. Injury in fact, 2. Causation, and 3. Redressability. The first of these requirements necessitates that the plaintiff show palpable injury to himself. The second element requires that the injury is caused by the challenged action. The third element is met when it is shown that that injury will be redressed by the remedy sought from the court. My client was certainly able to show that he had met the first and third elements. The damage he suffered as a result of this hack is extensive, and court-ordered damages would help him begin to put his life back into order. However, he and so many other consumers who have brought similar cases were not able to meet the second requirement. This standing requirement that shows causation must be traced directly to the company is nearly impossible to meet in a cybersecurity standpoint. The courts have held that because this data technically could have come from anywhere, he has no means of showing that it came directly from this cyber attack, despite the fact that we know This cyber attack occurred, and just a few weeks later, Mr. Dronefire lost everything. His case was derailed, and because we do not have concrete proof that could trace his stolen identity to this particular data breach, the courts refused to hear the merits of his case. Thank you.
We hear a lot nowadays about hackers and malicious criminals going after individuals' information for their own personal gain, or on behalf of another, such as those working for a federal foreign government or a rogue intelligence group. These bad actors are the problem, not hardworking Americans running legitimate businesses on Main Street. This bill unfairly points to businesses to right the wrongs of a larger societal problem that should be addressed head-on by our government. I urge you to take a closer look at the impact this legislation will have on millions of business owners across our nation and recognize the burden they will experience as a result. While we support common sense guidance around protecting information of our customers, we adamantly oppose this legislation as it's laid out that would require business owners to do backflips in order to even try to meet the requirements it sets forth.
In the absence of the court's willingness to make exception for the modern consumer, on behalf of my client, I urge this Honorable Senate to pass Bill S. 1199. Put serious thought into taking legislative action on this matter. What we're talking about is allowing for a mechanism to have injured parties have their cases heard. We need to create a forum that allows for people to have their evidence heard before a court. We aren't arguing for all businesses to be punished for actions they weren't at fault for. We are merely pleading for a statute that will force the judiciary to hear the evidence, the stories of these injured consumers. Creation of the statute would not be a guaranteed win for my client nor any other client. What it would be is a chance to have their case heard and to let a finder of fact determine whether the case has merit. With this statute, we're not advocating for strict liability. We're just advocating for a way for victims to have their day in court and have their evidence be heard.
Good afternoon, and thank you for having me. My name is Maria Ross, and I am a cybersecurity expert. I am here to answer questions and discuss both positive and negative implications of the Bill S. 1199. First, it is very apparent that in the U.S. we need additional consumer protection through businesses to ensure that malicious third parties do not compromise consumer data. On the other hand, we must ensure that small businesses and businesses that are not cybersecurity focused or telecommunications focused have received an unduly burden for this bill. It is clear in other nations, such as in the European Union, they have GDPR and other such consumer protection, and this is a step in the correct direction. It is important to note that in addition to this bill, consumers and businesses are going to respond with additional protections that may benefit or heed the overall government and economy of the U.S. It's important to consider that businesses might hire third parties to ensure cybersecurity has been improved, which could potentially add risk. Information can be de-identified, which might create an additional burden on the consumer. Finally, there is an opportunity to potentially use blockchain, which is known as unhackable when under specific circumstances, of course, for businesses to ensure that their overall system cannot be hacked by malicious third parties. Thank you.
Ms. Ross, you mentioned that a de-identification of data would place a burden on consumers. Can you explain what this burden would be?
That's a fantastic question. So of course, there is going to be a burden of de-identification that could be placed on consumers. A lot of businesses are going to attempt to cut costs while ensuring that they have higher security, which means that there's going to be multiple step authentication processes, which means that you might be in your living room logging in to a very simplistic account, and you might have to run upstairs to your bedroom to get your phone to ensure that you can log in, and that would be every single time that you log into an account. That creates an additional burden, and of course discourages the overall use of businesses online when you have to disclose your data. Additionally, they might require more information to the point where it would disclose additional consumer data such as biometrics. They might require some fingerprint scans or facial recognition, which once that information has been disclosed or breached, it will not be a thing that can simply be replaceable as a password. Finally, if there is a potential loss of information and the consumer's data has been de-identified, the bank or the company itself may have the inability to determine whose data they lost. If there was a breach in the system that has messed with the data slightly, they will see this information has been lost, but they will not be able to attribute it to any single individual.
What is blockchain? What would it do to help businesses and consumers? Why is it unhackable?
That's a very important question, especially in this industry. So essentially, blockchain is a system in which a record is kept. It is a record of transactions that are linked on a peer-to-peer network, or they are linked across multiple accounts and devices. In order for anything to be changed, at least 51% of accounts and computers must have the same information on it. So because of that, you cannot go to the past and change it unless you have a majority of the accounts on your side. Because of that, it is considered very reliable, especially if you are giving out the accounts to a wide variety of people. So these would be a private blockchain network, perhaps hyperlink fabric. And this would be a really fascinating utilization because only individuals within the company would have access to that information. It is considered unhackable because each line of code, so let's say that you have Maria and she has $20 in her account, or she's making a $20 transfer. That single line is going to take at the very least weeks to months to decode, and by the time it has been decoded and they only have that, the hackers will only have that information, they can't use it because it's already a couple of weeks old. Furthermore, let's say that it is hacked. I call it the Titanic scenario. So far it hasn't been hacked. The only way that blockchain has been compromised is through the majority of computers being utilized to change records in the past, which is nearly impossible in this type of business scenario. So in the Titanic scenario, where someone creates a super computer that hacks and decodes this in maybe a day or two, it is very easy to determine what happened, what information was disclosed, where the hack or the breach has occurred, and what account was linked to this breach. A potential drawback to blockchain is the current use of systems. So if you have a pre-existing system, it's not very easily interoperable. So you might have to either transfer all your information to blockchain or use one of the platforms that is specifically looking into making that connection continuously. I hope that clears some things up for you.
Ms. Ross, tell us about the cyber attacks. Where are these attacks coming from? What purpose do they serve?
Absolutely. So a lot of these attacks are going to be coming from countries that have individuals that we won't necessarily have the ability to extradite. There are extradition principles, however, the process to prosecute is a little shaky within these countries. So it's a lot of places like Russia, India, China, and Pakistan are common locations where there are violators and malicious parties who are trying to attack these businesses. I think it is really important to note that there are two types of attacks. So there are attacks of opportunity and there are targeted attacks. And essentially, the targeted attacks are specifically for companies that hackers know they will get a lot of information, they'll get a lot of money or data from. Attacks of opportunity are much more low level. Those are individual instances where maybe a company does not have sufficient protections. They aren't using anything beyond their laptop Excel. They have very low security measures, and this is what this bill would specifically be targeting. So, for example, in the case of Mr. Drone Flyer, he was an example of an attack of opportunity. So the SOB Inc. did not provide sufficient precautions, and one of their employees went and visited their local coffee shop, from my understanding, and there was an individual who was able to hack into the network, get all the login information since the employee was logged on to that cafeteria network. Because of that, all that Devin Drone Flyer's information was disclosed. So in these instances, it's really important for businesses to understand that they have low-hanging fruit, very easily pickable data that could be taken by these foreign agents. This bill would really just target these, for the most part, opportunistic attacks. And while it would hold accountable companies for targeted attacks, it as a whole would protect consumer data in a much more simplistic situation and ensure that businesses are held to a higher standard of security.
We're running low on time, Ms. Ross. Is there anything else you think the committee needs to hear or needs to know before we end our committee meeting?
I think it's really important to note this is an extremely complex issue. It's not simply easy enough to say that consumers need protection. They absolutely do, but also businesses cannot be held to an unlimited amount of liability for any breached information. This bill is a very important step in the correct direction. However, in the future, I think it's very important to note that we are going to have to be a little more industry specific in terms of what standard of care businesses have towards their consumer data. A big US bank of the world should have a higher duty to protect information than your local sandwich shop like Dave's Cosmic Subs. I think at the end of the day, again, this is a very complex issue. We are taking a step, but it'll take some time to develop the necessary laws to protect consumers without placing a really large burden on businesses, especially ones that are local and small. Thank you for having me.
Thank you all for actively participating and engaging in this topic. As we move forward, our constituents are counting on us to do what is right and what is in the best interest for all persons involved, including businesses. If enacted, this law will spark national attention and bring our beloved country in closer alignment with its duty to protect the personal and private information of our people.